everybody. How's everybody this morning? Good morning, Muffin Top. Good morning, Al Anders. Okay, K Mitch. Hello, Looby Loo. Hello, everybody. Hello, Fluffy Hedgehog. Mary T. There's my sister. She's saying good morning to everybody. Hello, Georgie. Lorna. Hello, everybody. I try, Helllanders. I try. I think there's been 1 or 2 times I've been late. There's Kat. Hello, Kat. Hello, Git. Good afternoon from Sweden. Wow. Good morning, everybody. Tanya, Cece Cummings, TK Sass, Elizabeth Gregory, Looby Gulf Coast Girl. Oh, Glory. Hello and good morning, everybody. So we've got a bunch of stuff that was filed. The defense is trying again to have everything dismissed. So I'm going to bring you that. So let me get this all set up for you so I can share my screen. Okay. So this is a supplement to the motion for discovery for sanctions. There's 12 pages in this. We've already heard about this. Hello, Sharon Copper, Joy Wilson. Hello, everybody. I'm assuming that the judge still has not made a ruling on sanctions. So we're just going to briefly go through this. If you guys want to read through everything, we basically already heard about a lot of this, but this was just filed. They're so late in their filings. So I will scroll through it. So once the live is done, if you guys want to read it word for word, you'll be able to pause it and read through this. Good morning, everybody. Hey, Matt in the house. Good morning, Ann's Asmer Schernerworth. I can't pronounce that. I'm so sorry, but good morning. Yeah, we should all be sitting down for this, right? Good morning, everybody. Good morning. So this is what they filed, the motion, the supplement to the motions for discovery for sanctions between February 28th and March 8th. So this is their motion here. Mr. Morphew, by and through the undersigned counsel, renews and supplements his motion for discovery sanctions and for sanctions resulting from the prosecution's egregious violations of Colorado Rule of Criminal Procedure 16, the court's June 2nd, 21 case management order, and the Colorado and United States constitutions. Prosecution just produced additional evidence that should have been produced months ago. It reveals not only past violations, but a pattern of continuing violations. Now, we did kind of discuss this the last time he was in court, that they can only give them stuff as stuff becomes available for them, even though there may be reports and whatnot that were completed. The prosecution had not received the hard copy of them yet, so they could not produce them to the defense. So a lot of this you're going to see is them complaining about not getting stuff that the prosecution knew was completed, but the prosecution hadn't got a hard copy of the results or whatever that they had said that had been completed, like testing and stuff like that. They didn't get the hard copy of it. So how can they produce it to the defense if they don't have a hard copy of it yet to produce? So like I said, a lot of this is going to be stuff that has already been gone over, but being that they're just filing this whenever they want to and making us wait, a lot of this is stuff that we already know that's been discussed. So The prosecution has trickled out information that has been in their possession since May 2020 over the past week rather than complying all at once in a timely fashion. Now, we also know via the last hearing that there was problems with the defense being able to open certain disk files or JPEG files or this or that because they didn't have the right equipment to open those files. So it's not that the prosecution didn't give it to them, it's that they didn't have the proper programs, I guess. I don't know a lot about this IT stuff, you guys, but I do know that there was a lot of stuff that was sent to the defense that the defense couldn't open because they didn't have the proper programs or apps to open it. So it all had to be put together again in a different kind of format, which takes a lot of time when you're looking at, like, especially a 131-page arrest affidavit. So I get it. But they are complaining that this stuff wasn't turned over in a timely fashion. As of today, multiple additional items of information favorable to the defense has not been produced to the defense or have been withheld for months and then produced after multiple discovery sanctions hearings. Certainly, the discovery is not being produced as soon as practicable pursuant to Rule 16. The late and not produced favorable discovery are enumerated as follows. There's 12 pages here. I don't know how much of this you guys want me to actually read, but we'll go through a lot of it briefly. So in February 2022, an email to the prosecution, defense requested Range Rover, PowerPoint, and OGB files, the Exhibit A. I will show you all those exhibits, you guys, if you want. So let me know right now, because if you guys want to see all the exhibits, there's 41 pages. So if you want me to just scroll through it so you guys can go back and look at it at a later date, put one in the chat. I'll wait to see what comes up on that. And what I'll do is I'm not going to read through it all the exhibits. I will just slowly scroll through it so you guys can go back and watch it. Okay. I will do that once we get through this. And you'll be able to read through it just by pausing the video once this is uploaded to YouTube. And don't forget, you guys, once we're done the live here, it's going to take about 20 minutes to half an hour for it to be available on YouTube. Okay. So even though you may not be able to access it right away, know that within 20 minutes to half an hour of the live being done, it will be available for you guys to see everything. It just takes a bit for me to be able to get the description in and whatnot and get it set up properly. Okay, so they're complaining here that they requested stuff from the Range Rover data that they didn't get. Like I said, we heard about this, and I did go over a lot of this in my last live, so I don't want to waste your time and be repetitive on it. So if you do want to read through all this, you can rewatch this once the live is over. It takes about half an hour for it to be uploaded fully to YouTube. So then they're saying, then in March 4th, Mr. Holbert advised the court that the defense never conferred with them prior to filing the D-17. This statement was false, as evidenced by the February 28th email attached as Exhibit A here too. So I will show you all those exhibits. After the March 4th hearing on March 6th, the defense once again emailed Holbert with the February 28th conferral email and once again requested the data. To date, there's been no response. On February 24th, DDA Robert Wiener represented to this court that a dart cannot be fired from a regular firearm. This was flatly contradictory to a statement the prosecution attested to in documents filed in this court. So you're going to see this too. These darts can be shot from the dangerous weapon. The possession of the short rifle is one method that the defendant may have used in the murder. In open court on February 24th, Mr. Weiner confirmed that the statement in the prosecution's D58 response was not accurate. So then they go on to say the evidence that a dart cannot be shot from that gun is highly favorable to the defense. On February 25th, the defense requested documentation of the statement and favorable evidence. See Exhibit C to this motion. The prosecution did not respond. The defense followed up by requesting this information again as part of the March 6, 2022 email. Prosecution has not responded to either request. On March 3rd, the day before the motion sanctions hearing on the D17C, prosecution provided additional discovery identified as Discovery Packet 24. As a result of the late production arriving the day before the scheduled March 4th hearing, the defense was unable to do anything but skim through the discovery prior to the next day's sanctions hearing. After the March 4th hearing, the defense was able to read the material provided and learned that in the violation of Rule 16 and this court's orders is included material such as emails that were created long ago, May 20th, 2020, and which were given to the prosecution sometime between November 21st and January 18th of 2022. But the texts and emails were not produced to the defense until March 3rd. This is 4 to 22 months after they were created. It's okay, Cindy. The discovery received on March 3rd includes CBI email indicating they have self-determined that they will produce electronic correspondence on a 2-month cycle. Like, this is a lot of stuff for the prosecution to get through and to be able to send this out. And the thing with this, if they have an ongoing, I know in our office, if we have an ongoing form or in the program that we add new information as it comes available, if we add to that and then send it over to the prosecution or defense or whatever the case may be, you get the full file, not just the added part. The whole file is sent again. So if they say 2 months ago they sent every email that they had up to that date and sent it on over to the defense, and then they have more that came in that they add to the end of that, that whole file is sent again, not just the new stuff. It's sent again with the new stuff added. So could it be that they had been reading through emails and didn't see certain ones, and then when the new information was added and resent again, they did happen to come across it, that maybe something that they didn't think was important back then? I don't know. But I do know that this is a lot of stuff to be sending over and keeping track of what's been sent, what hasn't been sent. As far as I know, from what I've understood so far, is that everything that the prosecution had up to the date that they were discussing it, they had sent. Anything new is sent as they get it. So, you know, if the defense gets something that they can't open, that doesn't mean that they did not get it. It means that they don't have the programs to open it. So I think there's a lot of confusion in this. I know they redid everything and resent everything. So, I mean, it's just crazy. So like I said, this is a lot of their fighting that's been going on. This was already heard at the sanctions, but they're saying that they didn't get stuff. Like I said, I'm going to scroll through this. If you guys do want to pause it at a later date and read all through it, feel free once it's up on the YouTube channel, which takes about 20 to 30 minutes once we're done the live. I keep repeating that. I'm just going to put, hang on a second here. Oh, what the heck? Sorry, you guys. I'm just trying to put something across the bottom so I don't have to keep saying it. Okay. Okay, so we're just going to put that across the bottom so I don't have to keep re-saying it. Okay, so a representative sample of the favorable information produced on March 3rd, months after it was supposed to be disclosed, include the following. May to July 2020, text string between multiple CBI agents and possibly CCSO deputies involved early on in the investigation. Okay, so I'm not going to go through all of this, but they're saying all this they didn't get. Well, if they didn't get it, how do they know it's there, right? Again, you guys can read through this if you want to. It's just a lot of things like regarding Joe Cahill that we'd already heard about and whatever. Okay, so there was also November 21st, there was an unresolved match from 27-1, which is the glove box of Suzanne's Range Rover, that has a match to somebody in Maryland. The Maryland DNA was produced to CBI, but not produced to the defense. And the conclusion reached by the CBI and Maryland CODIS representatives that the match would remain unresolved. And I do believe that this was like the other ones that were found. They were partial matches to partial matches in CODIS. So they could be those partial matches matched thousands of partial matches that they had in CODIS. So they're not usable. And this is why they're not asking to redo the hearing to see if there's probable cause to send him to trial. Because the only reason that he was released on bail was because there was no evidence back yet or no results back yet regarding this DNA. The only DNA that results that did come back was they were not a match to Barry Morphew. So with that, it gave reasonable doubt that it could be somebody else. But because that these are those partial matches that they found are not relevant to the case, they could not have been used now to get him out on bail. So that's why they don't want to do the probable cause hearing over again, because he would not be let out on bail, because these partial matches that are partial matches to thousands of partial matches in CODIS, they're irrelevant at this point, because they could be anybody from somebody who worked on that Range Rover to a prior owner of the Range Rover to somebody that a friend. It could be anybody. So we go through this, and these are they were asking for the nondescript written notes dated 11/18/21 titled Morphew Hearing Debrief. You're going to see that when I scroll through the exhibits. But this is just basically everything that they said in their argument to have the case dismissed last time, and we're still waiting on the judge to decide on that. Being that they have now filed a second motion to dismiss, I'm assuming that the first motion to dismiss was denied. So they're really hitting hard on this fourth CODIS partial match. Like I said, if you guys do want to read through all this, you can rewatch this once it's uploaded to YouTube and read all through this. But it's basically just going over again what was argued in the last hearing. They're trying to say that Cahill can't be trusted, that he's going in front of a hearing for disciplinary. Well, it's because his firearm was discharged at home, had nothing to do with the case. And also a comment that he had made that he thought that they had brought this, that they had gone and arrested him too soon and stuff like that. That was just his own personal belief. But they're really trying to nail hard on that he's lying, that he said one thing, now he's saying another. I mean, like I said, it's getting close to his trial starting, and they're going to throw anything and everything out there to see if anything sticks. Because they're now saying that all witnesses that testified on March 4th, 2022 provided exculpatory and impeaching statements. So like I said, I'm going to scroll through this. We've already heard a lot of this. I want to get to the new one that's been filed. As Mr. Morphew has stated repeatedly, and the prosecution has never disputed, this court has substantial authority to enter sanctions when a violation is intentional or when a pattern of violations is shown. People versus Lee, and they cite another case here. Stating the bottom line is, as stated in the People versus Lee and other cases where there's willful misconduct or a pattern of neglect demonstrating a need for a modification of the party's discovery practices, there's a rationale for a deterrent sanction. Ultimately, it's up to the court whether or not a deterrent sanction is appropriate. Because of the multiplicity of the considerations involved and the uniqueness of each case, great deference is owed to trial courts in this regard, and therefore an order imposing a discovery sanction will not be disturbed on appeal unless it's manifestly arbitrary, unreasonable, or unfair. So it's citing other cases here, citing more cases. Here's some exhibits here. You will see them. I will scroll through them in full. There's another one here to an unknown Dave. I will show you these right now. I'm going to just scroll through them because I'm not going to go through the 41 pages. There's 41 pages up here, as you guys can see. And then, okay, so what I'm going to do is I'm going to go through this first. Or should I just... Okay, let me just see here. Okay, just let me... Okay, so I'm going to just scroll through. These are all the exhibits. Some of them we are able to see, some of them we are not. There are more pictures of inside of Suzanne's Range Rover that we haven't seen before. There's also the handwritten note that she was just talking about in her filing. So let me just scroll through this so the people that do want to read this can read it. Like I said, there's 41 pages. So let me just scroll through this and then we'll get to the latest filing. And like I said, once the live is done, you guys will be able to pause the video so you can read all this in full if you want to. That's why I'm just scrolling through it. I will stop on some of them to show you things maybe that we haven't seen yet. So just bear with me while I scroll through this. What was this one? So this is they are answering back. It's not like they were ignoring the defense. Exculpatory means, oh, okay. After yesterday's shenanigans with Franco, defense counsel should have sanctions, yeah. Okay, so generally CBI litigation packets are sent via FedEx to our Salida office. We do not have that at this time. When we get it, we will make it a priority to discover. So it's not that they were trying to, hold anything back or whatever. As they were getting stuff, they were passing it on. See, CIB Lab let us know that they produced an L-24 along with the litigation package and comm log to the DA's office yesterday. We would appreciate production of that pertinent discovery today. Well, if they haven't got it yet, they can't give it, right? So she sent this on March 1st. On March 1st, she sent this at 10:47 a.m. Like, we found out that CBI Lab, the CBI Lab let us know they produced an L-24 along with the litigation package to the DA's office yesterday. We want it. So within half an hour, the prosecution responds. Iris, generally CBI litigation packages are sent via FedEx to our Salida office. We do not have that at this time. When we get it, we will make it a priority to discover. So as soon as we get it, we're sending it to you. But no, just because CBI said they sent it yesterday doesn't mean that the prosecution already has it and can send it off. You know what I mean? So it's like within half an hour, it's like, you got it, we want it. So like, give us a bit to get it to you. We don't even have it yet. It's at the Salida office. We got to get that. And then we can send it to you. And this is what I meant when I was talking about the first documents that we looked over when they're trying to get sanctions and everything for the prosecution, not sending them stuff that they want. And the prosecution clearly states, look, it goes FedEx to our Salida office. We do not have that at this time. When we get it, we will make it a priority to discover, which means to send to you. So, I mean, they're shooting themselves in the foot here. So like I said, if you guys want to read through all this, you can. Once it's uploaded to YouTube, you can pause it. I just feel it's very repetitive. They're wanting every little thing. Like, good morning, I received multiple messages and I have multiple conversations with Andy Mormon over the last few days. Andy, as you know, has changed his direction in this investigation and fully believes Cody Cox is involved with the disappearance murder of Suzanne. Today, Andy sent me the attached photograph of a bronze or tan colored vehicle missing. So like, even stuff like this that may or may not have any not relevance, but it's just every single thing that they say they want a copy of. So asking if they can give access via Google Drive or SmartForce, because some of I believe it was one of these that the defense couldn't open. So we can do brief interviews and everything that everyone can see. They're trying, you know? So they've done everything that they could possibly do. I'm not concerned about that. I mean, it wasn't made by an officer, Dana, or, I mean, this was just Andy Mormon's thoughts, like, you know, the family. Oh, maybe it could be him. Maybe it could be him, you know, like, so I don't know. They've got the right guy charged with her murder, as far as I'm concerned. So like I said, sounds great. If there are any other SF related questions, please let me know. I'm on the admin page. So this is from the CBI. So, I mean, this just goes, they're really shooting themselves in the foot here, because they're showing that it's not only CBI, but all police and Chaffey County and everything are doing their best. I'll make sure it gets done. So it's like, I know you must be swamped. I just wanted to give you a brief update that Kylie and I are monitoring social media and news. Like they are really trying to keep everybody up to date. Okay, so here's one picture here. Oh, I can't make it bigger on here. That we didn't see before. And it shows like hand sanitizers, some iPods, some gum, a few other things that are in her console. This picture here this is her purse, actually. And there's a picture here. So there's another one of the floor. So they sent the pictures over that they had taken. And that was Derek Graham. CBI photos in Smart Forest folder P20 1889 TA photos 8. Atkinson took some pretty good interior pictures of Suzanne's car that may assist. No measurements. So, I mean, they sent this all over to the defense. So, like, see, even stupid ass things like this, teamwork saves lives. CDPS, public safety, post deers, CDPS, every two. Thumbs up. Thanks. How you guys doing? Colback and I are headed back to the Springs. We will be back tomorrow at 0930. Chris with crime scene at the house. Unfortunately, there's no cell service. So even stuff like this, that's really, is this what you're fighting about? Is this what you're fighting over? Okay, like whoever this Dave is, hey Dave, I'm en route to a missing persons case. I really don't have any other info other than the sheriff suspects foul play. The wife is missing. Husband left yesterday around 5 a.m. to Denver. It's in Chaffey County. I'm unable to pull a case number because F8 is down. So do you have any suggestions? They ask how long it'll take to get there. Greg says 3.5 hours. I can try to pull it when I get in. Is that a Pueblo call? Yeah. So it's like, are these really text messages the defense is fighting, saying they didn't get? Like, I could see if there was something in a text that said, we just seen the husband throw something out his window. I could see where they would want that. But these are just like, hey, I just got a call. I've got to go to Chaffey County or whatever. I got a call. Okay. I just don't get it. Like, is this what you are fighting? And this is what I mean. They're throwing everything they can at the wall to see what will stick. Sounds good. Good morning. I have a meeting about Morphew right now and may miss our BIO manager meeting due to it. I'll try to jump on if we end early. I'm in the CODIS conference and will be unable to attend. Like, really? Just colleagues texting back and forth saying, okay, well, I can't be there because I'm in this meeting. And this one saying, well, I can't be there because I'm in this meeting. So, okay, so here's the written notes and log that they were talking about in the filing that I just went through when we first started. And like I said, you guys can scroll through this later, pause it, and read it. Make less scientific, more readable for cops, attorneys, being mindful of how we're representing others. They're talking about the purpose of a community log with the record information, clarifying the correct spelling, date of birth, evidence, testing weeds, what makes something eligible for CODIS. Just notes that somebody took. So this is a communication log. More Iris Eaton, Rachel with Rachel Roberts. This is on 10/29/21 at 3:30. Hearing limited. Discovery hearing may not need to be there. Ask about labs. So this is just a note somebody wrote to somebody who's going to attend one of these hearings on what they want asked. I believe that this is Iris Eaton asking Rachel Roberts, or ask Rachel Roberts about this stuff. So she's giving for each sample do, auto, and for, question mark. If she says no, ask when she decides. Typically do auto on all four. I believe that that's the samples. Up-to-date version of case file. Do you do comparisons in this case? Items to each other? Yes. So somebody is maybe putting in this answer that, okay, I asked this question and she said yes. I don't know. It all depends on how they are. But this is Iris Eaton giving notes to somebody to ask these questions, I guess, in court. I believe that maybe these are the answers that were given to the questions asked because they look different, a different writing. Like I said, if you do want to go through these 42 pages and read everything word by word, you're more than welcome to watch this once it's uploaded to YouTube. Oh, somebody's pen ran out. No matches. Yeah, see, I think this is somebody asking this question and somebody answering because CR doesn't remember. CR explained this was a keyboard search voluntary process, not sure of exact dates. Did you write a report? CR explained a report not created. If no match, it's an evaluation. Did she review the 3 that went out? Doesn't recall if she looked at those. Did anyone ask her opinion? Match comes from CODIS. NDIS procedures, any associated with CODIS is investigative lead for them to follow up on. Yeah, because a partial match to a partial match is not something that is slam dunk. So when you go back and review items in this case, there are a lot, and this is what I was saying. There was a lot of unknown males in the case. There was a lot of unknown males that came back because it was the partial matches that they got when they put them into CODIS. They got matches on other partial matches. So it's not a hit. And there were thousands. that partial matched partial matches in CODIS. There was thousands. So they're really not usable. They could be anybody from the previous, whoever the previous owner was of that Range Rover, to people who worked on the vehicle, to people who maybe test drove that vehicle before Suzanne bought that vehicle. It could be anybody. Yeah, it has to be a hit. A hit is an absolute match. A hit is, we know who this print belongs to. It belongs to John Doe. A match means that it matches other prints. So it could be one of many. So when you get a partial match to a partial match, it's like you got thousands and thousands and thousands of people that it could be. When you get a hit, that means that, say you've got your fingerprints on file, your full fingerprint, and they run a print against your fingerprint, and it is a hit, which means it 100% matches your fingerprint. That's a hit. A match or partial match is without a lot of other evidence to back up that partial match with other DNA or other things that put that person there or in that area. It's irrelevant because it could be one of thousands. So like I said, if you guys do want to scroll through this later and pause it, you can. It's just stuff that we've already heard. She's just giving, she's filing with the court her notes and her exhibits of where she's asking CBI or Chaffee County, where's this, where's that? And they're telling her, look at, we, you know, it's being sent. It comes by FedEx, but we don't physically have it yet. We'll get it to you when we do. Stuff like that. It's going to make her look silly. Like they can't give you something that they don't have yet. Even though, you know, the testing may be done, that doesn't mean they have the hard copy report yet. Just because it's been sent by FedEx doesn't mean it's in their hands yet. Yes, Shivani, that's why I'm just going through this quickly so I can get to the new. Now, this is what I'm saying, you guys. They tried to get the case thrown out, dismissed already. I am assuming that the judge denied it. We don't see anything in the filings yet that I can see. But I'm assuming, and I could be wrong, that the judge has denied it. So now they have filed another motion to dismiss based on more crap. And I'm going to show you that as soon as I get through this. And I believe that's it. Oh, and here's a little sticky note that sticky note from Stephanie. Place to go through these emails. Cody, please go through these emails. CODIS concern by end of week, Wednesday. This looks like the date has changed. Somebody changed the date from something to something. I don't know. So even a sticky note, it's like, are you kidding me? Okay, so there's all the exhibits, you guys. So now we're going to get to this. A motion to dismiss based on presentation of false testimony at pretrial hearing. This is 9 pages. So because they couldn't maybe get a dismissal, we don't know if the judge has made a ruling because they're taking forever. This was filed the 9th after the last court hearing. This was filed on March 9th. It only got to the record yesterday or the day before. Okay. So they're taking their sweet time getting this into the record so we can all see it. So I am assuming by this motion now being filed that the judge denied their last motion to dismiss his charges. Yeah, no court stamp, eh? It may be at the end, Matt. We'll see. We'll see come the end. I haven't read through all of this yet. I know that there's a lot of citing in this one too, so we're going to skip through a lot of where she cites other cases and just get to the meat and bones of it. Okay, so the motion to dismiss based on presentation of false testimony at the pretrial hearings. Mr. Morphew asked this court to dismiss all charges in this case. Factual background. The multiple and continuing hearings on D17 and D28 have revealed substantial evidence that law enforcement personnel testified falsely, and the prosecutor presented this false testimony in pleadings and at pretrial hearings on key issues related to the litigation. This conduct has destroyed Mr. Morphew's right to a fair trial. When these witnesses testify at trial, Mr. Morphew will have the right and obligation to point out to the jury that in this very case, on that very witness stand, the witnesses told falsehoods in an attempt to cover up the truth about the investigation. It will be imperative not only to point out the factual, reasonable doubt, but to raise doubts about the law enforcement officers presenting the prosecution's evidence. Even without an impact on trial, the falsehoods are prejudicing Mr. Morphew's pretrial litigation. It is patently unfair to make Barry Morphew face trial on the shoulders of this false testimony. He asked this court to dismiss this case because a fair trial cannot be held under the circumstances of these falsehoods and cover-ups. The court heard this evidence and is undoubtedly identified for its falsehoods in the evidentiary hearings before this court. A partial list of some of the topics of false testimony include reason for Barry Morphew's arrest on May 5th, 2021, falsifying a CBI's support for Mr. Morphew's arrest. Okay? This is where they're trying to use Cahill's personal and not professional opinion that he didn't think that they were arresting Barry too soon, that they should give it a little bit more time so they could do some more interviews. That's what they're trying to say, that he lied on the stand. Reasons for removal of primary investigator CBI agent Joseph Cahill from the Morphew case and major crimes unit. This was already discussed. Agent Cahill said him leaving the major crimes unit was for personal reasons. It was taking too much time away from family. He felt like it was stressing him out too much and that he wanted to move to a different unit. This was before he discharged his firearm at home and shot himself or something in the hand or whatever he did, which they had to investigate as per protocol. When your weapon is discharged, there has to be an investigation as to why, even if it was at home, had nothing to do with this case. So they're trying to use that. Presenting unsupported, false, undisclosed testimony regarding the CODIS matches at the preliminary hearing to convince the trial judge to find probable cause and keep Mr. Morphew from being released on a no bond hold. An extraordinary high bond. Prosecution requested $10 million. Well, wait a minute. They didn't have to convince Judge Murphy of anything, really, because Judge Murphy is the one who signed the probable cause arrest, the affidavit for probable cause. So I don't know what they're going on about, because if the judge is the same judge that signed the arrest affidavit, you're going to damn well almost can guarantee that he's going to sign he's going to find there's probable cause, because if he didn't find probable cause to go to trial, then he signed a fake arrest affidavit, right? because he signed off on the arrest affidavit that there was enough to arrest him for it. So why wouldn't he be finding probable cause in the actual hearing, right? Because Judge Murphy did both. He signed off on the arrest affidavit, which was 131 pages, and he's hearing the probable cause hearing to go to trial, right? Filings, pleadings with false information. The falsehoods and cover-ups are already prejudicing Mr. Morphew's ability to litigate his motion to dismiss. They will inevitably find their way into the trial as the credibility of these prosecutors and law enforcement officers is challenged. Ultimately, the district attorney is responsible for the presentation of false and misleading testimony. Her attorneys effectively endorsed the conduct by presenting witness after witness who testified falsely. As an example, the district attorney herself worked to remove the primary CBI investigator from the case because he would not testify regarding the CODIS matches according to her script, which was crafted to mislead the court as to the significance of the CODIS matches. Well, that's wrong. Therefore, the case precedent related to a prosecutorial misconduct applies to the circumstances here, where the prosecution has put forth theories before the court and presented witnesses to support those theories, even though the prosecution and often the witnesses know that the theory is believed by the actual facts and the evidence presented is not true. Further, the prosecution's failure to disclose the false statements directly implicates the credibility of the witnesses, making such disclosures mandatory. Okay, so then they're citing some cases here. Failure to disclose material evidence, including inmates' statements casting doubt on credibility of state star witness, violated defendant's due right process. Contrary to what one of the prosecutors stated at a previous pretrial hearing, the prosecutor's job is not to lock people up. They're just citing they're citing cases now here with Berger versus the United States. If you guys do want to read through this, you can. Just showing how it's violated and blah, blah, blah. Okay, so the knowing presentation of false evidence by the state is incompatible with their rudimentary demands of justice. Furthermore, due process has similarly offended the state not to soliciting false evidence allows to go incorrect when it appears. Okay, so they're still stating another case here. The prosecutor is charged with the duty not only to seek convictions, but also to see that justice is done. In his position as a public officer, he owes the duty of fairly dealing with the accused. So they're just citing what a prosecutor is supposed to do. And like I said, if you guys want to read through all this, you can. But they're just basically, here's another case they're citing here. The false testimony in this case has been introduced at pretrial hearings, and the false statements by the prosecution have been both written in pretrial litigation and stated in court. However, that does not make the conduct any less reprehensible. The falsities have still been made in furtherance of the prosecution's effort to secure a wrongful conviction. There is no free pass to present false testimony just because a jury is not involved. The fact that a witness has testified falsely at pretrial court hearing is relevant and admissible at trial as impeachment evidence. The significance of impeachment evidence is determining the outcome of a criminal prosecution often matches that of substantive exculpatory evidence. And they're going to cite some more cases here. I said, if you guys want to read through the cited cases, you're more than welcome. I'm just not good. It's just repetitive. Pretrial false testimony and the prosecutor's reliance upon it continue to be profoundly prejudicial to the defense. It gives this court a biased view of the issues, prejudices Mr. Morphew's presentation of his claim, and the prosecution has violated the due process clause. The prejudices for this motion for dismissal and other sanctions. There is a reasonable likelihood that because it has to now be proven at trial, it will end up affecting the judgment of the jury. Okay, so many of the same questions have been asked since August 2021. How can prosecutors be allowed to lie without consequence? This is how the criminal justice system works. Oh, is this how the criminal justice system works? Well, you're part of it, so, but anyway. But this conduct is not just and cannot be rationalized to Mr. Morphew or his daughters. To force Mr. Morphew to continue to carry this boulder up the trail mountain, weighed down by the ultimate consequence of being sentenced to life imprisonment without parole if wrongfully convicted, by his daughter's emotional welfare, by his financial resources, in the face of the endemic misconduct orchestrated by the prosecution, is wrong. Mr. Morphew's right to a fair trial on the charges has been obliterated, and there is no way to clear up the path to a fair trial. Mr. Morphew makes his motion and all other motions and objections in this case, whether or not specifically noted at the time of making the motion or objection, as a continuing objection based upon, in addition to the above mentioned authority, the following grounds and authorities: due process, trial by jury, right to counsel, equal protection, equal access to administration of justice, right to defend life, cruel and unusual punishment, confrontation, compulsory process, right to remain silent, and right to appeal clauses of the federal and Colorado constitutions and the First, Fourth, Sixth, Eighth, Ninth, 10th, and 14th Amendments to the United States Constitutional and Article 2, Sections 3, 6, 7, 10, 11, 16, 18, 20, 23, 25, and 28 of the Colorado Constitution, Criminal P16. Mr. Morphew cross-references and incorporates by reference all pleadings filed or to be filed in this case and case law cited herein and at oral argument. Wherefore, Mr. Morphew asks this court to dismiss all charges. So there you go. So now that we're done that, I can look at chat and see what you guys are saying. Yeah, like I said, they're throwing anything and everything at the wall. The trial is a month out. We're going to see a lot of this. We're going to see a lot of crap flinging. They are going to do everything in their power to get this thrown out. It's actually, as much as we don't like Barry, we don't like the defense, this is not something that's not foreseen by the prosecution. Especially in high profile cases like this where you're getting life sentences. They've got nothing to lose by throwing out anything and everything they can. This is pretty much normal for the defense to keep throwing out motions to dismiss, and each time they find even a comma that is not in place properly and could make something sound different than what it was intended to mean, they're going to throw it out there for a dismissal. They're grasping at straws at this point. And I do think that it's going to be denied. So those are the new filings in the Barry Morphew case that we have got. Let me just check one more time, you guys. And there's been 1,000 jurors already subpoenaed with jury subpoenas. So basically, with what they're saying now is with this fourth hit, they're saying that that CODIS match is linked to somebody in Maryland and was not produced to the defense, and it remains unresolved. The 3 previous CODIS partial matches have been ruled out by the prosecution. So basically, to give an overview, the reason they're asking for the dismissal now is they're saying that the reasons weren't proper for Barry's arrest, number one. Falsifying CBI's support for Barry's arrest because Cahill had said, I don't think it's the right time. And when questioned about that, asked why he thought that, he thought that they could get more information out of Barry, that they could conduct more interviews with Barry and possibly get him to slip up on something. So he wanted a little bit more time to conduct some more interviews. They're also using the reason that apparently Linda Stanley wanted Joseph Cahill removed because he wasn't following what she wanted him to testify to and stuff like that. Agent Cahill did clear that up and say the reason he wanted off the major crimes was I can't talk today, was because it was stressing him out. It was too much on him. His anxiety was going through the roof. He wanted to change back to something less stressful. And he had already put in a change out of major crimes before this even happened. So presenting unsupported, false, undisclosed testimony regarding CODIS and the matches at the preliminary hearing. I don't think that there was anything there that was not false or undisclosed. They did mention it. And filing pleadings with false information. I know that there was a couple things that they didn't have dates. The dates or something were wrong on their filings, or something was said out of context that they corrected. I know there's minor things that had to be adjusted or talked about when they were questioned about certain things. I think that was cleared up. So them using this now, I don't know. It's okay. Let me just go and check to make sure that there's nothing more on Barry yet. Yeah, nothing else has been filed. The D53. Did I show you guys the motion for discovery of ongoing full disclosure, any records, materials, or investigation? I don't know if I showed you guys that. Hang on, let me just see here. Oh, that was filed. Hang on a second, you guys. Just give me a second. I'm just checking to make sure that I have showed you guys everything that I have. I'm telling you, it's a lot to go through here. Okay, I can even show you guys. This is what I'm looking at right now. This is what I'm looking at right now. So I got to find the one I just seen to see. That's a default. Okay. I think it's this one. Because this was filed March 16th. Okay, so this is, I don't think I showed you guys this one. Have you guys seen this one yet? It's 3 pages. Have you guys seen this one yet? I don't know if I'd shown this one. I don't think I did. You put a yes or a no in the... Right. That, like I said, Shivani, that's already been discussed. And that's why I'm saying, I don't know why they're, like I said, they're just throwing everything at the wall now to see what will stick. Okay. So I didn't show this one. Okay. So this is another order that this is the order from something else they filed that we are not privy to. So we're not allowed to see the defense's 53 motion for some reason. It's not in the filings, but this is the order regarding it. This matter comes before the court on defendant's D53 motion for discovery and ongoing full disclosure of any records, materials, or investigation of prospective jurors, D53, filed on December 7th, 2021. Let me see if I got it. Hang on. If I don't have it here, it's because I didn't get it. No. So I don't have it. Okay, the people filed their response, D53 response, on December 23rd. On February 9th, the defendant filed his reply in support of D53. The court heard additional argument from the parties of jury procedure conference on March 10th. Okay, so this is the one we weren't allowed to hear about. The court has reviewed all of the briefing argument and pertinent law. Being fully advised, the court finds and concludes and orders the following. So when was this? March 16th. We'll see the date. What's the date on this? March 16th. So this order was made on March 16th. The defendant is charged with first-degree murder along with other counts for the alleged murder of his wife, Suzanne Morphew, on or about May 9th to 10th, 2020. Defendant is pled not guilty. A jury is scheduled to commence on April 28th. Applicable law. The court dealt with the public defender's request for access to certain public records. It has been in the practice of Pueblo for a number of years for the police department to provide the district attorney with the conviction record in traffic and criminal cases of the prospective jurors. I do believe we did go over this, you guys. Testimony abducted before the trial court showed that before each term of the district and county courts, list of prospective jurors for that term is delivered to the Pueblo. Yeah, we did go over this. Yeah, we did. This is where the defense was asking for the names, I think. But let's go through it. The test is okay. Beside each name on the list are noted any convictions in traffic and criminal cases. These lists are then returned to the district attorney's office. They are made available to the trial deputies for their use in jury selection. So they send out all these questionnaires. They get the questionnaires back. Okay, so it's a Pueblo, the police department, that send out the questionnaires. The Pueblo Police Department get the questionnaires all back. Beside their name on a list, they make a list of everybody who's returned their questionnaire. Beside their name is any convictions in traffic or criminal cases. Okay? Once they get all the questionnaires back, what they do is they take out anybody who has criminal cases, convictions in criminal case, or they send that list to them with any convictions in traffic and criminal cases. Okay, so I believe that the Pueblo Police Department sends to the district attorney the list with any criminal convictions that they have. Then the district attorney then chooses which ones, I guess, are serious charges or whatever. So if they have criminal convictions or anything like that, they're removed from the list. So what this was that the defense wanted that full list, not the list of the subpoenas that were sent out to the jurors that were able to sit on the jury. So what they did is they weeded out anybody who had criminal convictions in either traffic court or criminal court. Okay. So yeah, I remember this. I went through this, but it was just filed on the 16th. It was filed on the 16th, but we just got it in the record. So, so what happens is once the Pueblo police give that full list with their convictions beside their name, the district attorney's office says, okay, well, this guy's been convicted of a criminal offense. We don't want him. We don't want him. We don't want him. They don't want anybody on there that's been convicted of a criminal offense, right? So out of whoever's remaining, that's who they send the subpoenas out to appear, amongst other things, okay? They're then subpoenaed to come to court for hearings where they're questioned and blah, 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 blah. Well, the defense says, well, we don't want just the list of the 1,000 that you sent out. We want the full list with their convictions next to their name. Even though they're not going to be used in jury selection, we still want that list. So with this, it was denied in part and given in part. So yes, I do remember now going through this before. Okay. So that's where we're standing at right now, you guys. It's going to be a shit show again. I'm going to keep an eye. I believe it's going to probably be done behind closed doors again, that we're not going to be able to see or hear anything that goes on in the court. Definitely the defense is fighting to keep all cameras out of the courtroom, even for the trial. So I doubt that we are even going to be able to see this play out. And this all goes back to this apparent WebEx hack that has been proven that never happened. Then they tried to say that somebody was sitting in the courtroom recording it and streaming it to somebody that lives in the northern latitude, which would be me. Actually, my name was brought up in court. They said that somebody was sitting in court and live streaming it to me. Blah, blah, blah. It's all been proven to not have happened. But being that there is now an order that the media cannot cover via video, we're not going to be able to see this, I don't think. So, which is shitty. Somebody, I believe, that either the defense put up to it or somebody who is pro Barry started a shit show that now keeps us from being able to get live tweets from the courtroom or to ever have a camera in the courtroom for this trial, which I think the media is fighting, but we'll see what happens with that. So, with that being said, that's about it, you guys. Yes, praying for the Mormon family. Like, it's just, you guys, I'm not too concerned about this. Like I said, this is normal for somebody who's facing life in prison. If they really thought that they could get a not guilty, they would go back and have the probable cause hearing redone. But they're not asking for that. You got to ask yourself why. Because they know that the only reason that Barry was released on bail was because all the information wasn't back yet on the 3 partial matches, which gave the judge reasonable doubt because we don't got any more information. And now they're complaining about that coming out in the probable cause hearing. They used that to get Barry out on bail, but now they're complaining that they didn't have the full report on it. But not having the full report, because the full report now states that it has nothing to do with the case, he wouldn't have been released on bail. That's what you used to get him out on bail. So you used it to get him out, but now you're complaining about not having the full report on it. But not having the full report is what got him out on bail. You see what I mean? This is why they don't want the probable cause hearing redone again, which would be a sanction that the court could place on the prosecution. The probable cause hearing is going to be redone. Defense doesn't want that, because then that means he's back in custody. They have the probable cause hearing, and they've got to show that there's probable cause and get him out on bail again. They don't want to do that because there's no glitch there now to get him out on that. Everything done from that probable cause hearing on would have to be redone also. So you can't use things that were done after that probable cause hearing to use in that probable cause, a redo of the probable cause hearing. So, you know, they want their cake and they want to eat it too. Oh, we want to use their mistake or lack of full report on these possible matches to get him out on bail. But once we got him out on bail, we're going to use that against the prosecution and ask for a dismissal because they didn't give us the full file on that. Like, it's shooting yourself in the foot. You know what I mean? And because they're not asking for a redo of the probable cause hearing, it's not on the table for the judge to offer that or to order that. So it's a shit show. It's a shit show, you guys. So with that being said, if there is nothing else that you guys have, oh, so that's what I've got, you guys. So if anything else pops up, I will jump back online and bring it to you. Don't forget that once this live ends, it won't be available. So if you're in the middle of watching it, it will be back up publicly in 30 minutes. Okay, so even though the live ends now, it takes about 30 minutes to be available again on YouTube. So please do not think that it's gone, that you guys aren't going to be able to see it. It will be available. Once this live ends, it takes about 30 minutes for it to be available again on YouTube. Okay, so with that, thank you all the mods. Thank you for being here. If anything else comes up, I will let you guys know right away. And with that being said, thank you everybody for joining in and watching along. Thank you to my mods. You guys are the best. Thank you to all my subscribers. Love you guys to the moon and back. Please take care of yourself. Please stay safe. Till the next time. Bye-bye for now.